This is Paul. I was just reading. This is from the Washington State Court Form, State and Local Court Rules. Yes. Oh, look at this. Northwest Justice Project, Administrative Office of the Courts, the AOC, list of helpful phone numbers and websites. Oh. Now, I know it's really important to understand exactly what to do when you get served. Yes. The clerk's office takes original. That's page 1. Yes. Page 2, look at all these words they give you. This is one of those helpful brochures that you can get. Terms you need to know. The following terms are important to know. Pro se, a Latin phrase meaning for oneself, refers to people who represent themselves. Can a corporation be pro se? Ouch. A government? Ouch. Then there's the ex parte, a Latin phrase indication action done for in behalf of or on the application of one party only without notice to the opposing party. There's only one ex parte order, the first protection order that's issued. Seemed that in 2011 you decided to issue an ex parte order. That's the only one you could have issued the whole time for over 7 years. All the other they would have had to been pro se, litigant. A general term to describe a party, plaintiff, or defendant to a legal action. A motion, a written request made by a party, or an oral request made by a party during a hearing or trial to a court for an order granting relief. A motion to dismiss. Petition, a formal written application to the court requesting a remedy available under law. What happens when the petitioner petitions the court, didn't confirm she was going to be in court on July 31st, 2015, didn't acknowledge the fact? And then there's the order, a direction or command delivered by a court and entered into the court record. Isn't that what a protection order is called? It has 2 words. Now, I would say, okay, if the petitioner did not confirm on June 12th that she would appear in court on July 31st, even though it was 50 days later instead of 14, for you to schedule a hearing without her appearing, I'm kind of thinking, okay, as we go through the audio and video of every court hearing since July 8th of 2011, if the actual petitioner that appeared at the court hearings did not affirm to the judge that they would be in court the next court date, for you to schedule a court hearing where they couldn't be there, well, I know it says 14 days, and King County said 2 to 3 weeks. Isn't that right? But I'm kind of thinking that these court hearings are somewhat important. Now, is it contempt of court to not appear in court, or was it not contempt of court when you didn't ask the petitioner on June 12th if she would be there on July 31st?